Yeah, they said that it would not be subject. Well, I don't know. It's in my system. Right. But they did find something that actually work.
We will be live streaming. Just want to let everyone. Thank you. All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Candace Krause presiding, is now session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have two cases set for argument today. I will call the cases, and if the attorneys would please state your names and your readiness to proceed. The first case for argument is C-230115, Rick Carlson versus City of Cincinnati et al.
Jonathan Hilton for appellant. We're ready to proceed.
David Lang on behalf of the city, ready to proceed.
And the second case we have is C-230133, MedPace Inc. versus Icon Clinical Research LLC et al.
Good morning, Your Honor. Scott McIntyre on behalf of the appellants, and we are ready to proceed.
Great.
Good morning, Your Honor. Mike Shire on behalf of MedPace, the appellee, and we are ready to proceed.
Great. All right. So, Mr. Hilton, would you like to reserve any time for rebuttal?
3 minutes, Your Honor.
Okay. I will be keeping your time. We do have lights at the podium, but I was told yesterday the stop light doesn't work. I don't know. But you'll have the yellow light come on when you have about a minute left of your initial time.
Thank you.
So whenever you're ready.
Good morning, Your Honors. Jonathan Hilton for Rick Carlson. May it please the court. The trial court below, on remand from the Carlson 2 decision, made one key factual finding. There was only one factual dispute that was at issue on remand, and the trial court found that fact in my client's favor. And that fact was, when the case was pending originally in Carlson 1, and the judges who were on the bench at the time raised the issue with counsel that the record, as it stood before the court, showed that Rick Carlson's $100,000 judgment was already satisfied. That is when the city learned of its mistake in its filing below. Nevertheless, the city waited until the first district had ruled. And the first
I
district...
don't understand how you say the court made a decision in your client's favor, because we told them to figure out whether the appropriate ground for relief under 60B had been satisfied, and they agreed, the trial court agreed that it had.
Well, Your Honor, the important thing in the Rule 60B-1 framework is that the city has to offer a justification for its mistake. And if the city knew...
And the court bought that justification. So why is that wrong?
Because as a matter of law, if a party knows that a document is missing from the record, yet it waits and it sits on its hands until the trial court, or in this case the Court of Appeals, has rendered a decision, then it can't go back and argue mistake. And it can't do that as a matter of law. So I would cite to the Breckenridge case, that's out of the 11th District. And then I would also...
When did the city find out about the mistake?
The city found out during oral argument.
Okay, and you're saying that when should they have done something about it?
So at the moment that the city learned that it had made this mistake in its filing, it was under a duty to correct the record. And it could have done that, I believe, through Appellant Rule 9E. The city pointed out, or the court pointed out in Carlson 2 that the city had an opportunity to correct the record at that time, but it didn't do so. Instead, it waited until after this court had already ruled that my client had satisfied the judgment.
I guess I don't understand, how would a 9E filing have helped here? Isn't this something that needs to be cleaned up at the trial court level?
At that point, it could have been done through Rule 60A, for instance. So the city could have asked for a clarification of the record and allowed for a Rule 60A motion just to correct the clerical mistake below in the judgment. So that would have been possible, but instead, the city didn't do anything in response to that, instead waiting for this court to rule.
Mr. Hilton, it's my understanding that at the, let's call it Carlson 1, the typographical error or mistake, you were unaware of that as well. Am I correct? And that's the first time you learned of it? Is it oral argument?
That's correct, Your Honor.
Okay.
And Mr. Parker, who is my law partner, Mr. Parker's response at the time, when he learned of the mistake, was to respond to this court that he would be happy to accept on behalf of his client a result finding that Rick Carlson had satisfied the $100,000 judgment.
Yeah. Because what we just have we have the satisfaction of judgment, it says Rick Carlson satisfied, and then there's the civil judgment or certified judgment, and we don't have access to that. All we have is a piece of paper saying that he's satisfied whatever the $100,000 obligation. And my understanding is the civil judgment was actually correct in that it would apply to Daisy. Am I correct in that? But so we don't have that information.
That's
we don't
correct.
get that file. We don't get that file.
So the actual CJ number that was cited was for Daisy Carlson's judgment, which is what that $8,000 had gone to.
So,
But nevertheless, the name was Rick Carlson. The service was on Rick Carlson of that satisfaction of judgment. And this court found in Carlson 1 that it was Rick who satisfied the judgment. And that wasn't called into question until Carlson 2.
right. Okay.
So in sum on that issue, once the trial court found that the city did learn of its mistake while the appeal was pending, in order for the city to actually then prevail on a Rule 60B1 motion, the city was required to show something besides gross carelessness, gross neglect. There's always some responsibility requirement built into the Rule 60B1 standard. And if you want to rely on a mistake, when you learn of the mistake, you have to promptly correct it at that moment. So what we have here is a record where, based on the facts the trial court found, there was gross carelessness and neglect as opposed to a mistake that was fixed while there was the opportunity to correct it.
How long did they, so they find out during oral argument. I didn't look at how long, so the case is submitted. How long did it take for the opinion to come out and then for them to file their?
1 month, Your Honor.
It was only a month?
It was short. It was 1 month.
And then as soon as the opinion came out, then they filed in the trial court?
That's correct, Your Honor.
Okay.
So, I mean, what from that is showing dilatory conduct? Because I think a reasonable lawyer might say, I can't really file something at the trial court until the Court of Appeals relinquishes jurisdiction, so I'm going to wait for that. They wait for that, then they file the trial court. So, like, where is the undue delay there?
So, Your Honor, I do want to distinguish between the reasonable time inquiry, which is not the prong that we're challenging. It's simply whether they're able to avail themselves of the mistake. And the rule that we're relying on here is that a party cannot rely on a mistake that it made after it learns of an adverse judgment. So it's not so much about a dilatory set of conduct so much as it is just legally, when it's brought to your attention, you at that point have a duty to correct the record before.
I'm sorry I'm having trouble following you, but like, if you're talking about a Rule 60 motion, it's always going to be by necessity after judgment. So something is going to happen that's going to alert you to the fact that there's a mistake surprise, something, and there's a judgment. So what am I missing here?
Your Honor, the key fact is whether you were notified of the mistake.
Okay.
So if you learn of something while a court's decision is pending and you fail to take action then, at that point, the case law says that you can't rely on your mistake.
Okay.
Now, let's say that the judges had not informed anyone at oral argument, and then they made the ruling. At that point, counsel could, if it could have shown that its mistake was anything other than the result of gross carelessness, which that's another standard. They also failed to meet that. They failed to put anything in the record on gross carelessness. But if they hadn't known, then they could attempt to rely on the mistake. They could have submitted affidavits showing a reason for the mistake. They could have presented evidence that it was something other than just gross carelessness. But as it is, they didn't come forward with that evidence. They had the burden of proof, and they came forward with essentially nothing. They didn't specify specifically the grounds for Rule 60b-1 that they were moving forward with, and they didn't present evidence on the issue. So as a matter of law, my client was entitled to prevail on the Rule 60b-1 issue, simply for lack of that evidence that it was something besides gross neglect or gross failure. The mistake has to have some responsibility element baked into it, and that's part of the case law. Are there other questions on that issue? Okay. Thank you, Your Honor. I will move on to some of the substantive issues with the judgment. So part of this court's mandate in Carlson 2 was that the trial court was supposed to correct any errors in the judgment before reinstating it. I believe that's paragraph 34 of the Carlson 2 decision directs the trial court to make those corrections to the substance of the judgment before reinstating the judgment. Instead, what the trial court's decision does is decide the Rule 60b-1 issue, enter a final judgment, and then delegate to the city the responsibility of filing post-judgment motions to correct the substance of the judgment.
Well, let me ask you, Mr. Hill, my understanding is the city concedes that there's a $3,500, I think it's Daisy's judgment, should be satisfied, I think. And then there's a $1,900, something along those lines for something that was outside the statute of limitations. And they concede that they're going to do that. They just said in their briefs they didn't have the opportunity because you appealed so quickly.
Well, Your Honor,
I don't want to waste a lot of time on it if there's something's conceded. I mean, it's up to you if you want to, but.
Thank you, Your Honor. So specifically what I believe to be conceded is that the VBML count for Rick Carlson should be reduced by $3,500, and that summary judgment should have been entered for my client as opposed to the city on count 4, which was nuisance abatement costs for $1,190.50. I agree that they've conceded it, but I don't think that we filed the appeal so quickly. There's a short amount of time to file the appeal. They're free to correct that record as well in terms of the liens that they've asserted against my client. It's a live issue. It's not moot because there are those liens in effect against my client right now. So as a matter of law, the court should reverse on those issues, the trial court, rather than simply allowing it to be delegated for an indefinite period of time to the city.
You are at your time if you would like to reserve 3 minutes.
I'll reserve. Thank you.
All right, thank you.
Good morning. May it please the court. My name is David Lang, and I represent the city of Cincinnati in this appeal. We're here today for the third appeal of this matter because Mr. Carlson wants to take an undisputed typo and turn it into a lottery ticket to avoid his judgment. Fortunately, as this court ruled in the second Carlson decision, Civil Rule 60B afforded the trial court the opportunity to correct that typo on behalf of the city. And specifically, the Carlson 2 decision charged the trial court with two particular issues. First, whether the city's motion was filed within a reasonable amount of time. And second, whether the typo should be amended to avoid an unjust result. The trial court answered both questions in the affirmative in the city's favor, and this was an issue that Carlson 2 entrusted to the trial court's discretion. So this court reviews on abuse of discretion standard.
And what about his argument that as a matter of law, this does not rise to the level of mistake under 60B?
I think this is undisputed mistake. The trial court's opinion explicitly notes that it's undisputed mistake. Mr. Hilton and Mr. Parker represented to the trial court that it was a mistake. They, in fact, represented to the trial court before Carlson 2 that not only was it a mistake, but if they thought the trial court actually had authority to reverse it, that they probably wouldn't even challenge it, but they thought the trial court, in fact, did not have authority under Civil Rule 60B. And as I understand their argument, it's more not necessarily whether the city made a mistake, but whether that mistake was excusable in some way. But I think when you look at the case law that they cite, Your Honor.
Right, capable of granting relief under 60B.
Yes, Your Honor.
So, go ahead.
Yes. And I think when you look at their case law is grossly disproportionate to what effectively is a Scrivener's error in this case. So Mr. Hilton cited the Breckenridge case. And here we're talking about a divorce decree. And that divorce decree, as we know, like in most divorces, is effectively a settlement agreement negotiated between the parties that is then adopted by the domestic relations court. And that decree was silent as to a particular class of property. It was income tax filings, and there was one other piece of property similar to that. And one of the parties wanted to go back and say that should have been evenly divided. And the 11th district there said, no, it was silent as to that. And because this was fundamentally a contract that was negotiated, that's not something that the court's going to go back and rewrite for you. Compare that to here, where we have an error that's admittedly an error. There's no dispute as to that. There's no dispute as to the city's timing here. The city moved timefully. We moved, so to Your Honor's question about when oral argument was, it was September 2nd of 2020. The decision came down September 30th of 2020. The city undertook two actions after that. So first, both on October 2nd, the city filed a motion for reconsideration of the Carlson 1 decision here, bringing to the court's attention that the release of the certificate of judgment had inadvertently released Mrs. Carlson, Stacey Carlson, instead of Mr. Carlson. The city also filed the motion to amend the release of the certificate of judgment in the trial court, which then Mr. Carlson moved to strike, and that's what led to the Carlson 2 decision. So regardless whether we're talking 30 days or 2 days, the city moved under a reasonable amount of time.
I think what they're not arguing that you weren't quick or relatively quick. They're saying that you didn't take advantage of the earliest opportunity to correct the mistake, which would have been while the case was still pending before decision here in this court. How do you respond to that?
So to that, I would say in the oral argument in Carlson 1, counsel for both parties represented to the court that they didn't know at the time, but they said that if the release was of Mr. Carlson as opposed to Ms. Daisy Carlson, that was an error. Mm-hmm. The city at that time did not know, based on that representation, whether this court would factor that into its decision or not. It wasn't until that decision was actually entered, the Carlson 1 decision came down, that the city knew that was then intertwined with the judgment.
Well, the city knew at that point that it could be factored in, and I guess the question is, could the city have even fixed that mistake before the decision here came out?
Correct. And I think that becomes a complicated issue because on the one hand, the case is in front of the first district, and so the trial court's deprived of any jurisdiction inconsistent with this court's jurisdiction. And
What about Appellate Rule 9 that was argued today?
again, I mean, I think as Judge Winkler articulated, it wasn't, the CJ itself was not part of the record. It was just a slip that noted that the CJ had been released. So it's unclear exactly where the city would have to file there. And given that, it was a short 28, 30 days, the city struggles to see, the city certainly feels that it moved as diligently as it could, given the level of complication involved with the issues, and that the matter was pending before the court at that time. Again, I would just like to stress that this court should review under an abuse of discretion standard. Mr. Hilton cannot point to an act on the trial court's part that is unreasonable, arbitrary, or unconscionable. The trial court certainly resolved these matters in a reasonable fashion. As the appellant, Mr. Carlson bears the burden of overcoming that presumption of the regularity of the trial court's proceedings. Finally, just to pass briefly on the other assignments of errors, 2 and 3, again, these are accounting errors. The city does not dispute that they should be corrected. It's just that we have not had the opportunity to amend their certificate of judgment, the release at this time. If and when we are able to do so, we will account for that.
Sounds like there's a lot of mistakes in this case.
Certainly, Your Honor. Certainly. And then as to the final 2 assignments of error, the motion for summary judgment against Mr. Carlson is supported on the same facts as the motion for summary judgment against the other Carlson defendants, which was affirmed in the first Carlson decision. And so the city at this time would ask that this court affirm the trial court's decision, allowing the city to amend the inaccurate typo.
All right.
Thank you.
Thank you. Mr. Hilton, you have 3 minutes.
Thank you, Your Honors. I'd like to call attention to some additional authority elsewhere in my brief. I want to point out the Bang To decision out of the 10th District. And what I cite that for, it's on page 19 of my brief, is for the proposition that when a party is put on notice that an item is missing from the record but does nothing, its neglect is not excusable. That is inexcusable neglect. And since the burden was on the city below to prove or to at least make a showing that it had not committed gross negligence in what it was doing, it failed to introduce anything establishing that, particularly in light of the fact that it was put on notice. Additionally, I would point out the 8th District has a case, Lindsay, also cited on page 19 of my brief, that says that the movement, so in this case that would be the city, has the burden to explain any delay in the filing. So again, this goes to the issue of whether there is the kind of mistake for which the court can afford relief. And they didn't come out with that explanation. And so I would respectfully submit on that issue that the trial court should have ruled in our favor as a matter of law. Moving on briefly then to the other issues, in terms of the largest part of the summary judgment that was entered against Rick, that $72,000 for VBML fees, the issue at stake there is that Mr. Cunningham's affidavit, on which the city relies, never specified the date that the VBML fees started to run against those properties. For Rick, this was very important because he had at least 6 properties where he didn't just start at that beginning $900. He was starting at a much higher level of VBML fees on the basis that the properties had been ordered vacant for a long time. So in difference from Carlson 1 that looks at the children and their properties, for Rick it's a much more important issue and it's more central to his case. The city can't come back and rely on their Exhibit H, which was submitted in their reply brief in their motion for summary judgment, because it was unsworn. It was unsworn, and it was simply a spreadsheet submitted by counsel. There was nothing in the record that they put in their motion for summary judgment to establish the key fact of when those VBML fees started running on the properties. So with that, unless there are any further questions, I'll rest.
All right, thank you.
Thank you, Your Honors.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day.
Thank you.
Okay, the next case is Icon versus MidPace. Or MidPace versus Icon. Mr. Yeah, I'm sure. Mr. McIntyre, would you like to reserve some rebuttal time?
Yes, Your Honor, 3 minutes, please.
3 minutes, and I will keep your time. Whenever you're ready.
May it please the court. Good morning, Your Honors. Scott McIntyre on behalf of the 17 defendants who are the appellants in this case. Your Honors, the trial court's unprecedented preliminary injunction order should be reversed, and with all respect, this is not a close call. Plaintiff, over the course of 2 years, has failed to seek any TRO, any preliminary injunction in pleadings or otherwise, orally, after filing 3 separate complaints in this action, including the amended complaint that's at issue here today. Plaintiff also has no claim of trade secret appropriation. They've offered no evidence of any lost customers, any lost revenue. They were forced to concede that the claim of $1 million of lost revenue is false, with all respect, and that's part of why we have a counterclaim pending that they filed a motion to dismiss on. Instead, plaintiff filed this action improperly, seeking to keep thousands of employees from seeking any job worldwide in any position. The court's order that we're here appealing has no limitations as to geography, has no limitations as to any job. It's unprecedented, Your Honor, especially in today's world where the NLRB and the FTC are cutting back on properly identifying abuses with non-competes.
Well, don't we
This is a
first have
perfect
to
example.
decide if this is immediately appealable? Isn't that our first question?
Your Honor, respectfully, we have briefed that issue ad nauseum, and we think that isn't a close call either, that this is appealable, and I'm happy to address that. But the briefs fully address that issue, and Your Honor's issue.
Well, let me ask you a question related to that on your First Amendment argument, because I was thinking about this morning. So my brother has a high-level security clearance, and let's say he just starts a blog and starts posting classified information on that. The federal government could come in and presumably get an injunction to stop him from that. So, like, does that create First Amendment issues? Like, I'm just curious how broad your conceptualization of the First Amendment is here.
Yes, interesting question, Judge. And
Yeah.
there's some case law in the federal court even talking about national security interest may not be enough. That is not presented here. What we're dealing with is the plaintiff's overly broad agreement. But the First Amendment is at issue in terms of speech here because we are prohibited from recruiting candidates. We're prohibited with talking candidates. That includes emails. I get an email.
Well, but that's not true. This says, the order says hiring, soliciting, or recruiting. So that doesn't prevent chatting with people. I mean, it's all in the context of people who have these restrictive covenants. So I think a reasonable reading of that is you can't go recruit them to join your company in violation of their agreement. And I'm just trying to understand how that creates First Amendment problems without just blowing up all non-compete, enforcement.
Yes, Your Honor, I appreciate that question. There is zero, how it doesn't create a problem is to go through the preliminary injunction process, file a motion seeking a preliminary injunction, set it for a hearing, go through the process and see if the Ramon factors and others are followed. But here, we have recruiting, and the court has been clear. She views this as a gag order. That's in the record. That's what she viewed this as, thinking that it's within her power to prohibit substantively, to issue an injunction, a cease and desist order prohibiting any communication. It's not just limited, frankly, it's not limited to any agreement. It's not tethered to the language of any agreement, Judge Bergeron. So you mentioned that it has those definitions, recruiting, soliciting, hiring, but these are at-will employees. There's no reference to any agreement. That's all undisputed. Based on the language in the agreements attached to the complaint, these are literally at-will employees, paragraph 5 or paragraph 6 of the agreement. So these are employees that have a right under Section 7 and under Ohio law. We cited the, two cases, that talk about how employee mobility is something that Ohio law protects. You don't have to cite some, opposing counsel says, don't worry about what the NLRB says. Don't worry about the NLRB, what FTC says. Well, Ohio law, the Johnacare case that we cite, and Ohio law has long said that these are construed against the employer. Free mobility, the right to work, the right to get a higher wage, that's something that's protected under Ohio law. And so that's all speech, Judge. If you look at the memo, Section 7, rights under the NLRB, this prohibits recruiting in the context of speech. Whether
But is this commercial speech only? Are we only talking about commercial speech here?
No, Your Honor. We're talking about all sorts of speech, commercial or non-commercial. But the case law we've cited says even if it is commercial, that's not a distinction that Ohio law matters, where it matters for appealability.
So you're saying it does not matter, but the prior restraint applies to commercial speech?
There's higher standards at issue under federal law for a prior restraint, but the definition of a prior restraint under Ohio law is if it prohibits the communication from occurring before, and that's subject to the highest standard under the case law we cited. And it doesn't matter whether it's commercial or non-commercial. Now, we've cited the case law, the Gold Coast case, that says hiring speech is speech in the context of recruiting agencies. And we get, as lawyers, we get email asking, do you want a job? I get a recruiting today asking me to vote, for example, through AI in a jurisdiction where I'm not even live. So
Don't vote there.
Yeah, exactly. But it's intentional. There's no intentional. Right. And this bars, we're thousands of employees worldwide, all over the world.
If you're saying, so I understand you're saying there's no difference here between commercial and non-commercial, and that prior restraint applies to commercial. But you also said that this particular order is prohibiting non-commercial speech as well?
It is prohibiting.
And explain that to me.
Yes, Your Honor. So, for example, we have some of these appellants who are no longer employed. That's part of why we have a counterclaim. One of my clients hasn't worked for us, either corporate defendant, for 2 years. She resigned her employee, Kristen Bell, the first employee here that they've sued. She hasn't worked here since September. She lives in North Carolina, has emotional distress due to this. She has counterclaims. They're axe grinding. It's the Arrow case versus Tarter. What this is about is they have a vendetta against Ms. Bell. She's prohibited in her current employer from even talking. For example, let's say she's a union organizer. Let's say she's asking to recruit somebody, is recruiting where she talks to them and says, hey, I like my current job. Why in the world would she be prohibited from recruiting somebody to be a recruiter, for example? She's never even signed a non-compete. That's an example.
But I guess if she isn't party to an agreement and isn't employed by you, I don't see how this agreement or this injunction could restrict her.
The order, Judge Bergeron, is not limited to folks who, everybody, all the defendants and all their employees. And there's case law saying that when an injunction is issued like this, its agents, even attorneys, are subject to.
It seems to be limited to simply commercial speech, hiring, soliciting, or recruiting.
Well, hiring, soliciting, recruiting, what does that mean? Is it intentional? Does recruiting mean? NCAA, for example, there are whole reams of lawyers who try to prohibit the NCAA from getting into trouble with college athletes for recruiting. That's not defined anywhere.
I'm just trying to determine how it could be non-commercial.
Yeah, well, it could be non-commercial because some of my clients are friends and neighbors with some of their employees. And so non-commercial would be, I love my job, you know, I'm
Is
doing
that
this
is that
interesting
hiring,
work.
soliciting, or recruiting?
That's
Saying
the
I love
question.
my job?
It's not defined. Is recruiting, does recruiting mean taking somebody to a lunch and saying, here's what I'm doing at work? I love this work. This is COVID-19 studies, for example. They sued my client, Mr. Amori, who they haven't sued in this case, the Hamilton County Court of Common Pleas. They actually sought a TRO and injunction, and they refused to grant it there. And so they haven't brought him in the case, for example. So his case involved, and some of these others involved, working with, this is in the public record, on these studies that led to the COVID-19 vaccine. This is interesting work. And so talking about the benefits in the public interest, that's prohibited under this agreement. They could say, well, look, I'm talking about this is what work I'm doing. I'm proud to do this. We pay higher wages. That's not commercial speech. That's protected Section 7 of the National Labor Relations Act speech. Recruiting includes union organizing. This is incredibly overbroad. It doesn't include any intentional, non-intentional language, but the broader point is that goes to the appealability. This is appealable because the bell can't be unrung. We cite the Peruski versus Corsi case that they haven't disputed, nowhere in their brief. So due to the fact that we have due process arguments, there was no request for an injunction, no hearing held. That case said that there was only 2 days hearing before the preliminary injunction, 2 days notice before the preliminary injunction hearing. That was ruled automatically appealable, interlocutory basis. That's an 8th District case. They haven't even addressed that in their brief. That case says this is immediately appealable, Your Honor. It's a murky question, Judge Bergeron, national security, but fortunately we don't have to deal with that here. The federal courts struggle with that kind of analysis. It's kind of like the Skokie case where you're having Nazi sympathizers. That's immediately appealable. As repugnant as it is, it's immediately appealable. But those issues, this is an easy reversal. Let's talk about irreparable harm. The Arrow case, this court has held 3 months delay means there's no irreparable harm. Actions speak louder than words. They sued Amori. He's working still today. They didn't get their TRO. They didn't get an injunction. I think that's why they didn't seek a TRO or injunction here. They want to leave this hanging out there as long as they can. My individual clients, one of them, multiple of them are no longer employed.
So what would stop you from, if we didn't reverse, from going in tomorrow or the day after the decision and saying, Judge, we're tired of this. We want to get a permanent injunction hearing set as soon as possible?
Good question, Judge. That would reverse the burdens. We, from the beginning of this case, remember the context of this. We were in court trying to get discovery, the agreements. We don't even have the agreements, the non-compete agreements. That's the subject of this non-compete. They haven't even produced them to the court or to us. We filed a motion which we were there to argue. And Mr. Shire jumps up and presents hearsay evidence, which he typed out himself, and something from 2001, before I could even say a word, and derailed the argument. And we still do not have an order. With all respect to him, we still do not have an order from the court giving us the actual non-competes. So it's insane, literally, with all respect. We're here arguing about a non-compete where they haven't even produced the non-compete agreements for which it applies. There's been no reference to actual language of the folks who have allegedly signed this agreement. From the documents attached to the complaint, they're at-will employees. They're overly broad, no limitations from janitor, from custodian to corner office. Everything is prohibited. This is the broad. We have never seen a case like this anywhere in the country, let alone Ohio, where they've took a sledgehammer and made a class action approach without even looking at the Ramon factors that are mandatory from the Ohio Supreme Court. Ramon says each case has to be analyzed on its own facts. Each agreement has to be analyzed on its own facts. Here, they've done none of that. They haven't even argued for any of that. Instead, they were able to convince the judge to misapply the law in such a way that has prejudiced our clients so that they can't even communicate, hire, solicit, recruit, whatever that means, for all employees, regardless of whether they have a non-compete or not. They've not even shown that the employee even knew about the non-compete. They didn't present the non-compete. The hearsay exhibit that they presented, which was written by him. None of the employees have gone to my clients. There's no attempted tortious interference. The case that we cited in our brief, identifies that tortious interference of a at-will employee, there's no claim for that either. And the agreements attached to the complaint literally say that they're at-will employees, and there's zero support for that. That's why they haven't sought a TRO or a preliminary injunction. They know the law doesn't allow for it. So it's much easier to do this end run. And you have the opportunity to correct the law and say, there's due process requirements under Rule 65, under Raymond. The courts have always been open. If they thought they had the evidence in the law to get a preliminary injunction, and Judge Giz even said this, file a motion. The law, these are lawyers who've filed 3 complaints without seeking it. And I think they did it because in the Amori case, they lost. They didn't get the TRO or injunction. We had a motion for sanctions, trying to get the agreements we're still trying to get from them, so we can file a summary judgment. We're trying to get our evidence to do this in the most efficient way, not a piecemeal fashion, Your Honor, to try to get everything we need. Take some depositions, frankly. We've been noticing a 30B6. We've been trying to do that. And instead, they say, nah, we allege $1 million in the complaint. We don't have any evidence of that, and we're not giving you any non-compete agreements. It's egregious.
You are at your, beyond your time if you want to reserve your 3 minutes.
Thank you, Judge.
Okay, thank you.
Good morning, Your Honors. May it please the Court, Mike Shire on behalf of MedPace. With me is Morgan Metzger, who is in-house counsel for MedPace. There's really nothing like oral argument to focus the mind. And when I kind of focused my mind after having written the briefs and some time passed, I focused on the Court's preterm decision because, Judge Krause, to your point about jurisdiction, to me that was a textbook. And this panel wrote that decision. That was a textbook on whether or not Ohio appellate courts, courts of limited jurisdiction, have, in fact, jurisdiction in any particular case. And really, it was, when I thought about that, I thought it could be a case that is put in law school textbooks because it makes some very important points that are pertinent to whether this court has jurisdiction, as you alluded to, which is the preliminary question in this particular appeal. And the court thankfully reserved our right to argue that, and obviously it was of some interest to you, Judge Krause. In preterm, this court said, without equivocation, our jurisdiction as an appellate court is limited by both our Constitution and relevant state statutes. We must honor the jurisdiction constraints imposed by our Constitution and state statutes. That's exactly the point here. There is no appellate jurisdiction at this point under either Ohio statutes or any other purported exception to statutory jurisdiction.
And is that because we're dealing solely with commercial speech?
That is why there's no exception
Right.
to the statute. But let me take a step back, kind of where I believe the first area of inquiry has to be, and that is 2505.02. And in particular,
Well, right, but I guess, you agree that this is a preliminary injunction for purposes of our analysis today.
the court called it a cease and desist order, and that order stands
I
on
mean,
its own.
what is that, though? I mean, an
I will-
order needs to flow from a rule of some sort. This, to me, looks like a preliminary injunction order. You're engaging in the preliminary injunction analysis. Is that what it is?
For purposes of 2505.02, it's a provisional remedy that it would fall under traditionally a preliminary injunction. So under 2505.02, because it's a preliminary injunction by the court, subject to revision, 2505.02b4 applies. In other words, this court has to look at that statute first before it does anything else to determine.
But what about the argument that the court bypassed the normal procedures for preliminary injunction that you and Mr. McIntyre are well-versed in? There was no appropriate kind of procedures, due process, however you want to call it, that complied with Rule 65 to ensure that the injunction was appropriate and was tailored appropriately. Like, what do we as a court do with that?
You as a court first have to determine whether it's time to do something about that. That may or may not be the case. I, of course, disagree with some of the premise behind your question, and that's fine. But to me, the preliminary question is it time for us as an appellate court to deal with it? And in preterm, you said the same exact thing. You said a lot of people want us to deal with this issue, whether or not
Very familiar with that, yes.
23 is ripe for appellate review. And you said, unfortunately, it's not. We'd love to handle it, but we can't. And that's this particular case. You might love to handle it. You might think Judge Giz did something wrong here. I'm prepared to argue she did not, but really, for me, that is a question that this court will have time to deal with when the time is right under the appropriate statutes that provide the courts of appeals with their jurisdiction. And again, it goes back to 2505.02, and the only subsection there that could possibly apply in this case is B4, and that applies to provisional remedies such as the remedy that we obtained in this particular case, and it requires a two-part test that this court, again, has analyzed pretty in depth in preterm Cleveland. And neither of the two prongs of 2505.02B4 are met in this case, and it's the only subsection.
And I don't think opposing counsel is saying that. I think what he's saying is that the exception applies because we are dealing with the First Amendment. We are dealing with free speech. And he is saying it doesn't matter if it's commercial or non-commercial speech. So how do you address that?
Yeah, that's flat out wrong.
Okay.
There's no Ohio authority directly on point, but the federal cases that the Ohio courts cite absolutely distinguish between commercial speech on the one hand and traditional speech at the core of the First Amendment at the other hand, such as a journalist's right to report events of public interest or political speech. That line of cases, the one-paragraph opinion in Skokie carries a lot of weight for one-paragraph opinion, and it kind of talks about the procedural requirements when traditional political speech is at issue. But that's a misdirection in terms of what applies when there's commercial speech. That's the Supreme Court's Central Hudson case, which in footnote 13, they specifically say that commercial speech is, I think they call it a hearty brand of speech that generally is not subject to prior restraint or overbreath analysis. And you don't need to look at only that case. That footnote actually has been written about quite a bit in the district court here in Cincinnati. Judge Susan Dlott wrote an opinion that we cite, the Henry decision, where she specifically notes that commercial speech, which is speech, by the way, it's easily definable. It's speech made in furtherance of a party's economic self-interest. There is no question that's a speech that's the target of Judge Dlott's order here. Speech that is made in the speaking party's economic self-interest. And Judge Dlott wrote in the Henry case, that is not subject to prior restraint.
So you disagree that this, because, hiring and recruiting seem to be pretty self-explanatory. Soliciting, for example, none of that is defined, or that's not defined. That couldn't include non-commercial speech.
Well, I would disagree with that in particular because the target is MedPace employees subject to an active proprietary rights agreement. And they're all attached to the complaint, by the way. So if you just look at the complaint in the case, the amended complaint, you'll see the agreements and you'll see the provisions. So the order was narrowly drafted solely to MedPace employees recruiting, soliciting, and hiring them when they're subject to an active proprietary rights agreement. There's nothing non-commercial about that speech. There's no reason to discuss with any of those people anything other than coming to join ICON, which is really the reason we brought the case, because that's happening all the time. So to my mind, as long as I can convince you that the order relates to speech in ICONs and its recruiter employees' economic self-interest, it is commercial speech. And although Kenjo out of the Sixth Circuit and even Judge Dlott's Henry decision are not jurisdictional decisions, what they teach us is that commercial speech is not subject to prior restraint doctrine. And why is that important here? Because ICON is arguing, and I believe some Ohio courts that sometimes this panel cites without analyzing it, got it wrong in that regard. Prior restraint is a doctrine, a very specific First Amendment doctrine that simply does not apply to commercial speech, and there is not a single case anyone can cite to out of the federal courts that says so, and there's not a single...
But you're acknowledging that there's not any Ohio precedent that substantiates this point.
I'm saying that there's no Ohio Supreme Court case that has there's no Ohio Supreme Court case that says commercial speech is or is not subject to prior restraint. And there are a couple of appellate decisions that I'm happy to tell you why they're wrong. This court has...
And those were more in the defamation context, right?
I think that's there's one in the defamation context. The one that really has kind of sent the analysis off the rails is the International Diamond Exchange case, which Your Honor cited in preterm, not to analyze, but to distinguish between what the government was arguing in that case. The problem with that particular decision, which really drives all the other decisions, including the Peruski site that Mr. McIntyre has cited the court to, and the Connor Group decision, those are kind of like the trifecta of decisions that incorrectly find for some reason, without any real citation of authority except incorrect authority, that somehow commercial speech is subject to prior restraint, and that also on its own finds that prior restraint of commercial speech somehow gives an appellate court jurisdiction. Those cases were just decided wrong. The International Diamond Exchange case, which you'll see you cite, maybe it's in paragraph 27 of preterm Cleveland for other reasons, was first of all decided under 2505.02b2, which didn't apply there and doesn't apply here. And then they go on and cite the Supreme Court's decision, the U.S. Supreme Court's decision in Skokie, for this idea that a state has to give either an immediate right to appeal or a chance for a party to stay the order suppressing the speech. But as I noted, Skokie is the wrong philosophical, intellectual, legal underpinning for how you analyze commercial speech and whether that somehow is subject to prior restraint. That is not Skokie. That's Central Gas. That's the Sixth Circuit's Kenjo decision that we cite, and that is Judge Lott's decision that I cited earlier, which unequivocally state, to the extent you're going to look to federal law in an area where the Ohio Supreme Court has not yet spoken, unequivocally, those cases distinguish between commercial and non-commercial speech as it pertains to prior restraint, which in turn drives whether there's an exception to 250502, and there isn't one here because it's purely commercial speech. And so although your honors might instinctually or intuitively think that Judge Giz did something from a process perspective that's incorrect, which I don't think she did, but let's just assume for purposes of this argument that she did, that's just going to have to be, by the nature of appellate jurisdiction, the narrow nature of appellate jurisdiction, that's just something that's going to have to wait for another day for this panel to look at or some other panel to look at.
Do you believe she complied with Rule 65?
I believe, let me put it more in a passive sense, Judge. I believe rules.
That's what I tell my law clerks not to do.
Well, I know that, but sometimes, the passive voice is a recognized means of of grammar in the English language, and sometimes it makes sense, and here it does. Rule 65, if you're speaking of notice and opportunity to be heard, was complied with, and that is because Judge Giz gave Mr. McIntyre and his clients the opportunity to challenge what she did through a motion to reconsider, which you can view as a motion to dissolve the injunction, if we're going to get that far. And I'd cite, Your Honors, to the Peruski case, which Mr. McIntyre referred you to. There, they cite a Sixth Circuit case that is right on point, and they cite it. And that case is Security Agency versus Ohio Department of Corrections. And in that particular case, the Sixth Circuit held, and again, it's cited by Peruski, which my adversaries rely on. That case is reported at 296 F. 3rd 477 at page 484. The Sixth Circuit held that, like here, in a case where the Icon analog argued we didn't get proper notice and we did not have the opportunity to be heard, the court said, okay, I hear that. That is all true, but that was cured. How? By briefing the legal and factual issues after the entry was ordered on a motion to dissolve the injunction. Everyone got their say. The trial court was able to then analyze the legal and factual arguments and make its decision. And
But I guess I understand that if it's a legal issue, but if it's a fact-based issue, if they're not on notice that this is a preliminary injunction hearing under Rule 65, so they're not prepared for that. Maybe they think it's another type of hearing, and then afterwards they get to file a reconsideration motion. That's all well and good, but did the court have all the facts before the court to ensure that they had their day in court?
Ironically, Your Honor, it did. And I say ironically because it's ICON that put that evidence before the court. Attached to their motion for reconsideration were the texts and the LinkedIn solicitations and recruitments by their client. And not only did they put in the evidence of the tortious interference, but they put in new evidence, including affidavits of two ICON employees, which was brand new evidence that we didn't get an opportunity to respond to. So at the end of the day, again, I don't have to repeat myself, Your Honors know my position that you'll have to get to this some other time, not on this appeal. But yes, I understand your concern from a process perspective, Judge Bergeron, but I will say that in this particular case, it was remedied, again, ironically, by the papers that ICON themselves put in. They didn't have to do that, but they did. They put in the evidence, they put in the legal arguments, they argued the four factors that courts look at. So my argument would be maybe a year from now or a year and a half from now in front of Your Honors, if I have the honor to be in front of you again on this issue when it's ripe for appellate review, I'll be able to show you that decision was substantively and procedurally correct. But again, just to take it all the way back, I believe that the underpinnings of jurisdiction here is, if you're going to look at International Diamond and you're going to look at that progeny, it's a rotten foundation. There's no basis for the jurisdiction for this court on this particular appeal.
Okay, thank you.
Thank you.
Thank you for your argument.
I'm out of time?
You are out of time.
Oh, okay.
Perfect timing.
Yeah, thank you, Your Honors. Appreciate the time and the attention.
Thank you.
Your Honors, may it please the court. I think it's telling that the focus was on an attempt to evade this court's jurisdiction by misquoting Peruski. Peruski literally holds this court has jurisdiction to consider this issue now, not 2 years in the future. Peruski literally holds that. Sea Lakes, 78 Ohio App 3D 476 that we cite in our briefs, there must be a hearing before granting a preliminary injunction. There is zero case authority to somehow fault us or any other party for filing a motion to reconsider, where we point out the law and the legal standards and ask the court to comply with the legal standards. It takes some amazing chutzpah to argue that a party asking a court identifying legal standards and the court doubles down on error, that somehow suffices as process for a hearing. That violates Rule 65. Sea Lakes, Ohio authority says it does. And real quickly on the question about jurisdiction. Speech directed at recruiting candidates is constitutionally protected. The Gold Coast Search Partners case we cited. Commercial speech, prohibiting hiring of day laborers, the Valley del Sol case, that's presumptively unconstitutional and immediately appealable. Prior restraints forbidding communications in advance and when they're supposed to occur. That's the Seven Hills versus Aryan Nations case we cite. The International Diamond Exchange case involves Stafford Jewelers. That's commercial speech. The Court of Appeals, Ohio Court of Appeals, held that was immediately appealable. The Toledo Blade case, which involved a, quote, gag order, which is what the court has said on the record it thinks it wants to do by prohibiting all of this speech, that is immediately appealable. These are Ohio cases. Just because they've sought a permanent injunction doesn't mean this is not immediately appealable. The Premier Health versus Snyderman case, 2001, Westlaw 1479241. So the speech issue, commercial versus non-commercial, we think we're right on that, but respectfully, opposing counsel still has not dealt with the due process issues that are clearly in play that make this case immediately appealable. And there's no question that the agreement, when you look at what happened here, is overly broad. This court can reverse this merely on the fact that they didn't seek one, or there's been no irreparable harm. There's been no argument that there's irreparable harm. This decision should be reversed on that basis alone. It's their burden to prove by clear and convincing evidence that they didn't even attempt to meet that burden. What they're wanting to do here is to keep this injunction out there so thousands of employees can't be hired for jobs having nothing to do with the non-compete. The exhibit that they reference was from 2001, and it was typed, that was an affidavit from 2001, or 2021, excuse me. That's stale by 2 years based on this court standard. And the employees at issue, they have not attached the non-compete. The person they identified that was allegedly recruited by virtue of an email wasn't hired. They haven't attached her non-compete. We don't even know if she has a non-compete. They haven't produced that. It's not attached to the complaint. That's wrong. What is attached to the complaint is an overly broad non-compete agreement that they knew, these well-experienced lawyers knew they could not get a TRO or preliminary injunction on by actually meeting the requirements, so they chose not to. That is what is undisputed here, and this court should not countenance this. This would be a precedent that encourages parties to evade the requirements of Ohio law and seek an injunction by calling it a gag order, calling it a cease and desist order, calling it something other than what it is. These protections are in place just so we're not here to incur this time, effort, and money to try to remedy our rights that we're guaranteed to under Ohio law that don't go away because we are forced to file a motion to reconsider at further cost and expense, pointing out the law that, respectfully, the courts should know already and apply. We shouldn't have to be penalized by filing a motion to compel and a motion for reconsider instead of immediately appealing. And we had to immediately appeal because we didn't get a ruling on our motion to reconsider until after we filed an appeal, by the way.
You are at your time if you want to wrap up.
Thank you, Your Honor. The Millennium case we cited places the burden of proving privilege or improper justification on the plaintiff in the tortious interference context as well. And that's the case we were identifying on the at-will basis. There could be no tortious interference based on the at-will language as well. Thank you, Judge.
Great, thank you. Thank you both for your arguments this morning. The case is submitted and we will issue a timely decision.
Appreciate it, Ron.
Thank you.